This Monday, the Senate Judiciary Committee will begin the confirmation hearings for Elena Kagan to be the Associate Justice of the Supreme Court of the United States. These confirmation hearings will give an opportunity to the public to see firsthand how important Supreme Court decisions are in their ordinary lives. There'll be many examples that we could give, from schools to consumer issues to personal lives, privacy, religious protections, health and the environment, workplace. In recent years, by a sharply divided court, they have reversed precedent and congressional intent and ruled on the side of big business over individual rights. Madam President, this is judicial activism, not judicial restraint. And I would hope all my colleagues would agree with me that the next Supreme Court justice should be on the side of individual Americans following legal precedent and congressional intent. I'm going to give one example. I know some of my colleagues are here on the floor will give other examples. I'm going to talk about workplace fairness and Ledbetter versus the Goodyear Tire case. Just to give you a little bit of background. Lily Ledbetter worked for 19 years at Goodyear Tire. And during that period of time, she was paid $15,000 a year less than her male counterparts doing the same work. This type of discrimination is prohibited by congressional statute under the Civil Rights Act of 1964. Within that legislation, Title VII specifically enacted to protect American workers from undue discrimination, including gender discrimination. When Mrs. Ledbetter found out that she was being discriminated against, she did the right thing. She brought a claim against her employer. Now, the only reason Mrs. Ledbetter knew that she was being paid less than her male counterparts was because a fellow colleague finally told her. This is not unusual. In fact, in most employment discrimination cases, employees are unaware of discrimination until an unexpected event occurs or undisclosed information finally comes to light. Mrs. Ledbetter went to court, stated her claim, and won. But guess what? After multiple appeals, the case reached the Supreme Court of the United States. The Supreme Court, by a 5-4 decision, denied her claims. The court said that Mrs. Ledbetter had to file her case within 180 days after the beginning of discrimination. And since she didn't do that, her claim was barred by the statute of limitations. Now, Madam President, this defies logic. How can a person bring a claim when she doesn't know she's being discriminated against? It makes no sense whatsoever. This decision appalled me and many of our colleagues. We were shocked. Whose side is the Supreme Court on? What happened to protecting American workers and not big business? What happened to following legal precedent? What happened with following congressional intent? We all should be on the side of the American people and the American workers. As the Judiciary Committee and the Senate convenes next week to consider the nomination of Elena Kagan, we need to remember whose side we are on. We need to remember that big business can and will fend for itself, but it's individuals that look to the court and looks to Congress to uphold the law and protections it delivers.